in part two of our trust series, we talked about taxes and trusts. But I know a big part of trust is also the estate planning piece. And so in part three, that's what we're going to talk about. Adelia, what does the estate planning part of trust look like?
So you're right. You can use trust for estate planning, not just tax planning. And there are many advantages to using a trust. And now we'll go through them together. So the first one is it minimizes probate fees. Have you heard of what probate is?
No, I was going to ask you that.
Probate is a process by which the trustee or the executor of the estate has to take the last will and testament to the court of probate, which charges a 1.5% fee to say, yes, this is the last will and testament of the person who passed, and that the trustee has the legal authority to deal with the assets of the estate. And once you receive these letters of probate, the trustee can take them to the bank or land titles and have the ability to dispose of the assets of the estate. It's a costly process because it's basically a tax of 1.5%. So when a family or a person has assets inside a discretionary family trust, those assets that are in a trust will not form part of the deceased person's estate, which generally translates into non-application of probate fees to those assets.
So money saving.
It's money saving, and it also avoids delays because probate of a will can be very time consuming. It obviously involves filings in court, which are usually publicly accessible. And in comparison, when a trustee passes away, for example, a substitute trustee can be put in place very quickly because the trust deed allows for that mechanism. And then that successor trustee assumes the administration of the trust assets, and with relatively little delay and relatively little cost. And the trust just keeps on ticking and keeps on performing how it was set up. So when you have proper planning, you avoid the need to involve the courts.
I love that. So with the proper setup of the deed, you can work on both the saving aspect and the getting rid of delays. You mentioned what would happen if the trustee passed away. What about if the trustee was incapacitated? You know, they no longer could make decisions because of the health state they are in. What happens then?
Yeah, the reality is that many of us will experience such an event, and the trust deed provides for a mechanism to help in that situation. So a trust can assist with incapacity planning by naming a substitute or a successor trustee who can assume the administration of the trust property quite quickly in a prompt manner upon the current trustee's loss of capacity. And again, this avoids practical complications because you have complications when there's a power of attorney and then it appoints someone else to be the attorney, and then that new attorney becomes the new successor trustee, and you may not have wanted that person's attorney to be your successor trustee of your particular trust. None of that has to be involved, or none of that mechanism has to be invoked. You get a successor trustee and it becomes effective upon the occurrence of the incapacity event.
Okay. And one thing you've talked about is succession. So I think succession is also a big part of the trust planning process. And I know from our discussions that that's really a one-on-one process based on your specific circumstances. So if that is something that anybody watching needs help with, we're very happy to have one-on-one conversations around trust and succession planning.